When my ex-husband waved his gun in my face, promising to shoot me in the back of the head if I tried to leave, I believed him. And I am just one of 4.5 million women who have reported being threatened with a gun by an intimate partner. Domestic violence affects 10 million people every year, with 1 in 3 women experiencing some form of physical violence by their intimate partner. According to the National Domestic Violence Hotline, the presence of a firearm in these abusive situations increases a woman's risk of homicide by 500%. What sounds like the punchline to a twisted joke is actually the harsh and cruel reality. The only difference between a battered woman and a dead one is the existence of a gun. Undeniably linked, intimate partner violence and gun violence impacts millions of women. And today I want to address the current gun prohibition laws in relation to domestic violence restraining orders and the loopholes that continue to prevent victim and survivor safety. Established in 1994, the Violence Against Women Act was a pivotal point in legislation history. This law strives to improve the criminal, legal, and community-based responses to domestic violence, sexual assault, and stalking. The act brought together representatives from the criminal legal system, the social services system, and private nonprofit organizations in an attempt to respond to the ongoing rise of domestic violence and sexual assault. With reauthorizations in 2000, 2005, 2013, and 2022, additions were made that include creating an essential legal assistance program for victims, adding provisions to cover immigrant victims, providing assistance for LGBTQ+ individuals, and expanding access to emergency and short-term housing protections for survivors. Additionally, the Violence Against Women Act placed firearm restrictions on domestic violence perpetrators subject to some restraining orders, but has not created nor required a method for the surrender of firearms by these dangerous offenders. This is known as the relinquishment gap. Current federal law prohibits offenders under restraining orders from possessing guns only if the abuser has been married to, lives with, or has a child in common with the victim. Known as the boyfriend loophole, this legal gap does not take into consideration that women are just as likely to be murdered by a dating partner as they are a spouse. Furthermore, this federal law requires that licensed gun dealers run background checks on all potential gun buyers. But a provision added to the Brady Bill allows for sales to proceed by default after 3 business days, even if the background check has not been completed. This loophole, called the Charleston loophole, allows domestic violence offenders to slip through the cracks when purchasing guns. In fact, from 2006 to 2015, 30% of gun sale denials by licensed dealers to those convicted took longer than 3 business days, meaning these licensed dealers were legally authorized under federal law to arm 18,000 prohibited DV offenders solely because the background check took too long. While this law and its subsequent reauthorizations made progress in addressing the correlation between intimate partner violence and firearm fatalities, inconsistency and under-enforcement show an obligation for greater attention to these two intersecting public health issues. And according to the National Library of Medicine, failure to close these gaps in the law can be attributed to the growing political polarization around current gun laws, with domestic violence-related firearm laws being progressively and successfully framed as another form of gun control rather than something vital to women's safety. Those in opposition argue that prohibiting the possession of firearms by a person who has not yet had the opportunity to be heard is a violation of both the Second Amendment and the Due Process Clause of the 14th Amendment. However, because this deprivation is only temporary, it does not constitute a due process violation. Equally important is the gun lobby's claim that intimate partner homicides can be prevented by arming the victims, a detrimental diversion from what research has shown to genuinely work. Per Everytown Research and Policy, there is no research that shows that ownership of a gun increases a woman's safety. In reality, studies show just the opposite, pointing out that women who purchased a firearm died by firearm homicide at double the rate of women who did not own a gun. Advocates of intimate partner and gun violence will need to take a multifaceted perspective on protecting victims and survivors. I believe lawmakers should execute three specific plans to ensure offenders cannot access firearms. First, it is imperative to strengthen state laws that prohibit domestic abusers from being in possession of firearms and require abusers to relinquish guns they already have. But true enforcement of firearms surrender requires all components of the justice system to participate. Second, the existing laws on firearm relinquishment must be implemented and enforced by state and local courts as well as law enforcement. Judges can order the surrender of firearms and ensure that abusers explicitly understand the requirement to give up their firearms, while also monitoring compliance with these orders. Law enforcement can assist through regular communication with the courts about compliance and should develop a system of storage for surrendered guns. As well, district attorneys can and should fully prosecute abusers found to be in noncompliance of the law. Finally, we must absolutely strengthen the federal background check system. Congress and state officials need to prohibit the transfer of firearms until the results of a national instant criminal background check determine that the buyer is not prohibited from possessing a firearm. For the background checks to be effective, states must immediately improve the quality of domestic violence records in the system, as reports show missing and incomplete court data. This also means that states must ensure that all domestic violence criminal records and restraining orders be entered into the NICS database in a timely manner. To bring it closer to home, a WIS Politics article from November 1st, 2023 states, with 96 lives lost, 2022 was the highest year on record for domestic violence homicide and murder-suicide in Wisconsin. With only 72 counties in Wisconsin, this equates to more than one person per county last year. How would such a senseless tragedy affect your community? But we don't have to live this way if we just stand together and say enough is enough. Studies show that having a removal policy, in addition to prohibiting purchase and possession, has a vast reduction in intimate partner homicides. And universal background checks would decrease homicides by nearly 50%. So how do we go about fixing these harmful gaps in the current language of the Violence Against Women Act? I urge you to write to elected officials or call the legislative hotline in Madison and express your concerns. It's dire that we push these elected officials to ensure necessary funding to these supportive policies for critical intervention. You can become an advocate simply by speaking out and spreading awareness. If you or someone you know is in an abusive relationship, please don't wait until it's too late to get help. Call the National Domestic Violence Hotline at 800-799-7233 or text START to 88788. In Wisconsin Rapids, you can dial 715-421-1511 for the 24-hour client line at the Family Center. Thank you for your time.